Well, this is Brian Klontz with Charitable Solutions. I see we've got a good number of people joining here. I want to make sure you note that you're in the right place, number one, and we'll be starting the webinar officially in about 3 to 4 minutes. Just another quick welcome. It's Brian Klontz with Charitable Solutions. We've got another 2 to 3 minutes before we will start officially. I think we have about, believe it or not, 400 or so, 450 I think, registered, so we're letting everybody pile in here. But I'll go through some housekeeping notes here in a couple minutes, and we will get started. Well, I have noon Eastern time, so for the benefit of everybody's time today, again, I want to welcome everyone. I think we've got about 200 already joined, and I think we've got another couple hundred here to go, but appreciate your spending the time with us today, and I'm eager for you to learn more about what my partner John Severson will be going through with Charitable Solutions for the new IRA rules after the Secure Act in 2019. So have a hopefully somewhat innovative concept that you might be able to use to help your donors give more and get some benefit as well. So I was going to go pretty deep into that during this call. So a few housekeeping notes. So first, this session is being recorded, so we will be able to provide a link to this webinar both to all registered attendees, but also we'll be including it on the National Gift Annuity Foundation website in addition to the Charitable Solutions website. We are not planning to send out slides, but there again we'll have this free link for recording to the extent you think it'd be helpful for others, or if you're not able to be with us through the whole session. Second piece is we will have a Q&A session at the end, so about 10 minutes. So there should be a Q&A button at the bottom of your screen that you can use during the presentation, and then Brad Caswell, another partner, and I will be doing some emceeing at the end in terms of determining what questions might be best for the good of the group. I will say, though, very importantly, any question asked, hopefully no matter how specific, we'll be able to follow up after the call to be able to go through that. So those are the key housekeeping notes. Let me double check to make sure I've hit all of the most important things. Yes, yes. We do have a couple polls planned, so we can learn a little bit more about you as we go through. So with that, I think it is 12:01 Eastern. We've got almost 300 now, wow, who have joined. And so I'd like to ask then to go ahead and go forward. We'll talk about the agenda. So I'm doing the intro now. We're going to talk a bit about the SECURE Act and what that means specifically for the stretch IRA concept, which was crazy popular, and I don't want to say almost a standard of retirement income beneficiary planning, but it was pretty close to that, and some of the changes and what this alternative may mean for your charitably inclined clients. So to that end, we'll go through, John going through the old IRA rules, what can be done with testamentary life income gifts of these IRD type assets, so from IRAs in particular. And within that, we're going to review both charitable remainder trusts and gift annuities briefly, and then really do a deeper dive into CRT as the testamentary alternative and the deepest dive into testamentary CGAs. So we've spent a lot of time and effort building out this product over the last 6 to 9 months, and now obviously it is ready for rollout, and this is our first wave of doing that today. And then talking about then really the compare and contrasting between the testamentary CRT and the testamentary CGA tax rules, and most importantly, sort of to the extent that a donor has an interest and you as a charity think it's a good solution, what some of those next steps are for implementation. So before we get started too, the next slide is going to be on charitable solutions and sort of our model, and many of you I know, and I've had some nice comments already in the chat function, but many of you we don't know. So very, very briefly, I'll take 3 minutes at most, but I'm the founder of Charitable Solutions, created the firm in 2003. We have 14 team members, so 11 more than are on the call today. And most importantly, our mission and passion every single day is to help make gifts happen that otherwise wouldn't. That is why we exist. And doing that through managing risk to allow a gift to happen for a donor to have the maximum charitable impact and to be either the bridge, the consultant, or actually the solution for donors to be able to make these types of gifts. So very, very briefly, sort of top right, I'll go sort of top right to left. We spend a lot of time in 2 areas, charitable gift annuity, which we're going to talk about today, both with risk management audits, actuarial reviews, reinsurance, other kinds of risk management for large concentrated risks. We've been doing that for over 20 years now, done maybe 300 or so CGA pool risk audits. Next one, sort of in the center there, very esoteric, I know, but we do a lot of these, interestingly, would be virtual currency appraisals and life insurance appraisals and audits. So to the extent anyone wishes to give you Bitcoin or Ether or Litecoin and you need a qualified appraisal, we do about 150 or so of those a year, maybe 200 or so life insurance audits a year for those donated gifts that need a qualified appraisal, and then audit some portfolios too. I've sort of lied a bit, so rather than going totally top left to right, I'll go then drop down charitable estate settlement. Gary Sneerson on our team, who was with Harvard for 11 years, handling their non-cash and complex gifts as well as charitable estate settlement, helps charities that run into issues, primarily more sticky issues relative to estate settlement, and in particular around non-cash assets. So that's a little bit more of our expertise, as you know. Bottom, we're doing about 60 to 80 days a year of CE speeches, donor speeches, board, obviously advisors, and that we're really transitioning over to more of a virtual model like this and others too. So then the top left is very much a core of what we do. So non-cash assets and gift annuities are the only 2 types of gifts that a charity can actually lose more money than the original gift. So this has been my professional obsession for the last 25 years or so. And so what we help primarily charities do is to either help them receive non-cash assets directly where they need some consulting support. That's about 5% maybe of what we do. And the other 95% would be where we have a national donor-advised fund, the Decamine Foundation, that does nothing but take in non-cash gifts. It's all it's ever done since 2003. Believe it or not, we've completed about $1.5 billion of illiquid gifts that otherwise were initially declined by the charity. So we have about $300 million a year. The last 3 years has been the average, do about 70 to 80 gifts a year. And we are averaging, believe it or not, the average donation size over the last 3 years has been $5.3 million. So these tend to be very large, about 40% real estate, 40% privately held business interests, and about 20% odd things that you could probably not even conjure up, some of the things that we do. So, but the bottom line is this, and this is so important, 100% of those gifts were initially declined by the charity. And in working with us for an average fee of about 2%, we take on the risk, we do the sausage making, and then we grant the net proceeds less that fee back to the charities that the donors are recommending, which are usually the ones they tried to give it to in the first place. And the final point, which is really the sponsor in essence of the webinar today, is the National Gift Annuity Foundation. So again, we're all about sort of outsourcing potential risk management, and we have a charity, National Gift Annuity Foundation, that issues CGAs in 49 states. We're the largest independent pool in the country, about $35 million in total assets, over 500 contracts for about 350 charities. So for those charities that are not registered in a state, if it's a non-cash gift, if they don't want to issue gift annuities at all, rather than saying no to a good donor wanting to do good things, they can refer to John Severson, who leads that group, and Mike Carey as well. And then we can then be the issuer. We're maintaining the asset, the liability, and then 100% of the residuum is then passing back to, just like the non-cash assets, the charity the donor is trying to give it to in the first place, or multiple charities as well. So that's us, sort of a quick intro. I think we're going to do a poll here, if that's okay. So Brad, do you want to maybe launch that poll so we have a little bit better understanding about who's on the call today, and primarily around whether you're issuing gift annuities or not. So if everybody take just a few minutes, got 360 people on the call, that is insane. But take a few minutes to answer these. They're all yes, no, so not a whole lot of math or complicating questions. Oh, I appreciate the support. You guys are much quicker on the draw than I would be. Got about half have already responded. Got about another maybe 15, 20 seconds or so. Have to be some of you going out to get coffee or something else. Okay, I think that's probably good. Brad, what do you think? So 45 seconds or so, and I know people are still responding. Definitely don't want to cut you off, but looks like about 68%, you can see there, I know, are currently issuing CGAs. Roughly a third are not, so that's interesting. How many of you issue indirectly through a community foundation, like a national Christian foundation or National Gift Annuity Foundation or local community foundation? So it looks like about a quarter or so are doing that. So that's interesting. 3/4 are not. And then are you organizations that don't offer CGAs at all in any way? So it looks like about 20% don't offer CGAs. So, well, very good. Well, thank you for that. And next we're going to go through my quick introduction of my partner, John Severson. So on the screen you'll see his background. And so, John, if you're able to click that through. But as that's coming up, there he is. So he looks better in person than the picture. I'll say that on the recording, John, just for you. So John's the Vice President of Gift Annuity Services at the National Gift Annuity Foundation. Been with us now, working directly or indirectly, at least 5 years. I could be off by a year or two, so forgive me. But I've known John a long time. Well before that, I was a fee-only financial planner, obviously CFP, chartered advisor in philanthropy, so deeply in the financial planning space, but with a lifelong passion that sort of oozes out of him in a wonderful way around charitable planning in particular. So in his next phase, really loves working with small, mid-sized, and large charities, helping them develop more robust plan giving programs broadly, but more specifically using the gift annuity as a tool to help the charities and to help you help your donors too. So you can read more about him. We've got on the Charitable Solutions website his full bio, which would be similar, but 40 years of experience doing this, which I think will shine through here briefly. So John, I will turn it over to you for the rest of this presentation. Again, I already see some Q&A popping up, which is great, and so just continue doing that as we go through, and then Brad and I will collate those at the end for John to answer. So thank you so much.
Thanks, Brian. Well, again, welcome everyone. A pleasure to be with you. I want to give you a little bit more background on myself. Many of you know Brian Klons because he's very famous, but I'm a lot less famous. I started my career in financial services in 1972. Just means I've survived, been around a long time. And it wasn't until 1984, 12 years later, that I went to a national conference in Boston and learned that there was this whole thing about charitable devices that were created in the 1969 Tax Reform Act. So for the first 12 years of my career, I knew nothing about charitable remainder trust, charitable gift annuities, charitable lead trust, didn't know they existed. Was never mentioned in any of my training, even though I had some professional designations by that time. And so since 1984, I incorporated charitable planning for high net worth individuals into our financial planning practice, which I am now on the twilight years of that, passing that on to next generation. So now I can focus my attention solely on helping nonprofits and their donors in the area of plan giving from a planner's perspective, especially on the implementation side. So this whole Secure Act of 2019 got my attention because I'm in all kinds of listservs and websites as a professional advisor. And I started hearing about well, we got to figure out a way to counteract this, what happened in the Secure Act, which I'm going to share with you today, and it often can involve charitable giving. So give me here's a little history on the Secure Act itself. The act was passed by the House, a bill in May 23rd of 2019, went into a spending bill passed by the House on December 17th of last year. 2 days later, passed by the Senate. They did get something done, can you imagine? And a day later, President Trump signed it into law. So when things happen, they sometimes happen fast. All happened around Christmas. No one was paying much attention. The provisions mostly took effect January 1st of this year, and it was the most significant legislation affecting retirement planning since the Pension Protection Act of 2006, more major than most people had even realized. There are three main changes that the Secure Act brought that relate to charitable giving. One, it removes the age restrictions on IRA contributions. If you're over 70.5 previously, you couldn't contribute to an IRA anymore. Now you can continue to contribute to an IRA, which means that those type of accounts will probably continue to grow rather than just deplete as we thought previously. Another interesting change is the change for beginning your required minimum distributions, which I'll dive into a little bit here. It's been moved out from 7.5 to age 72, after which there'll be a 50% penalty. But the charitable IRA rollovers or qualified charitable distribution age remained at 70.5. A lot of confusion about that. I still use my charitable checkbook from my IRA to do my charitable giving. Because I'm over age 70.5, if you didn't know. But here's the major impetus of the Secure Act and where it affects most of you and your donors. It eliminates the old stretch IRA for most non-spousal beneficiaries of IRAs and replaced it with 10-year payouts. I'm sure you've heard about this by now, and if you haven't, you'll be hearing a lot more. In fact, I really got into this then after the legislation was passed in January. The Stelter Company, my good friends there, did a wonderful webinar on the Secure Act and kind of laying it all out. And I said, whoa, there's something here that we can really latch onto from a planning perspective. And then a couple months later, our friends at Crescendo Interactive did one as well. So I've been granted permission from both the Stelter Company and Crescendo to incorporate some of their material into this presentation. Why reinvent the wheel when you've got the best people out there doing that for you? So here are the IRA withdrawal rules. You need to be conversant with this. And to think about it from an IRA perspective, if you're an IRA participant, prior to age 59 and a half, if you take money out of your IRA, it's not only taxable for income tax purposes, but you get hit with a 10% penalty because it was a premature withdrawal. These are designed to help accumulate money for retirement. You're not supposed to be using it to buy boats and vacations, although people do. Then from 59 and a half now to 72, you can take withdrawals from your IRA, just pay the income tax on it, no penalty. Now, after 72, if you say, I really don't need the money, I want to defer it some more, you can't, because there's a 50% tax penalty if withdrawals are not begun after age 72. So we call them required minimum distributions. They're required. You don't have to take it. You just get a 50% penalty if you don't take it. And so this is the way the average IRA owner looks at this. In the early earning years from their 20s through 59, they're accumulating. They're trying to ignore it. They're not trying to take any money out because of the 10% penalty. Then they can start pulling on it from 59 and a half to 72 on a voluntary basis, pay the tax if they need it. But 72 and beyond, we really consider it mandatory, or else you're subject to that 50% penalty. This is what IRA minimum required distributions look like. At age 72, you're supposed to take 3.9% as your minimum required distribution. And as you get older, that percentage increases according to a government mortality table. I'm told in 2021, they may be revising that table and maybe slightly lowering those percentages. Haven't seen anything on that yet. But this is what your donors are faced with if they're over age 72 and have any kind of a IRA or other qualified retirement plan. When you have an IRA and set it up, you have to tell the person that's helping you where you want the money to go if your death occurs and you haven't taken all the money out. Well, of course, you can name your spouse and you can name a non-spouse, an aunt, a cousin, your next door neighbor, a child, a grandchild. You can name a trust, or as I've recommended for years, you can name a charity for part of all of it. Those are your options as you think about beneficiary designations on your IRA account. So let's look at the spousal rollover. If you have a spouse and if that spouse is going to need those funds in case you pass away, you can leave the proceeds of the IRA to your spouse. They can then roll it over into their own IRA account, and then they can follow the mandatory requirements of just withdrawal after 72 based on their age and their life expectancy, not yours. And then they may designate new beneficiaries at that time. Basically, they get to start over as far as the IRA for themselves is concerned. So that's very typical. But you could also name a child as a beneficiary. Let's say your spouse is predeceased, you're single, or you're widowed, and there's no reason to leave it to your spouse. They're getting plenty of other income. Then many people want to name their children or grandchildren as a beneficiary. Under the new rules, they now have to take that out over 10 years. I'll get into that a little more, or else they get hit with a major penalty. There's some minor exceptions for children with disability or exceptions for minor children. But when you think about children and even grandchildren, when you're 20-something or 30-something and mom and dad or grandma and grandpa leave you an IRA, you're not thinking about stretching that over your lifetime. You're thinking about, let's see, there's that classic car I've always wanted to buy. I could really use an upgrade on my boat, and I've always wanted to take that luxury vacation to Hawaii. That's what often goes through the heir's mind. And this works into the strategy I'm going to present to help parents and grandparents maybe protect the children from those temptations. So here are the new rules for your beneficiary designation on your IRA. On a non-spousal IRA, the old law says they could take distributions out over their lifetime. Didn't have to, but they could stretch out the distributions over their lifetime, even if a child at age 30 inherited your IRA at your death. The new law says bye-bye to the stretch IRA for non-spousal beneficiaries. That beneficiary has to withdraw the entire account balance by the end of 10 years. They can withdraw it the first year, they can withdraw it the last year, they can withdraw it over 10, but by the end of 10 years, it has to be out or they get nailed with the penalty. This applies also to defined contribution retirement plans. That's not only IRAs, but 401ks, 403bs, even 457 plans that some might have, any kind of a tax-deferred retirement plan. And the effective date is January 1 for new deaths that occur. But if if you or a donor inherited an IRA from a relative prior to January 1, the old rules are still in effect for you. So these new rules do not apply to retirement accounts inherited, as I said, if death occurred prior to December 31 of last year. The surviving spouse who inherits their account will still be permitted to roll over to their own IRA and delay taking until 72. That still is in place. That is in place. But what we're really going to focus on are the children, the grandchildren, the nieces and nephews, the non-spousal beneficiary of your IRA. And so, you know, if you're thinking about for years, I've been recommending to high net worth individuals that, you know, the kids are already getting all of your other resources, all your real estate, your business interests and so on. Why don't you leave those fully taxable dollars to charity at your death, and that'll be your charitable bequest. It might even replace a will bequest. And of course, you just simply name the charity to receive part or all of the IRA account balance at death, and it goes to them, and it's done. Well, that approach is fine, except it does not provide any income for your children or grandchildren, which was the purpose of the stretch IRA. So a certain segment of donors said, no, I want my heirs to receive my IRA. I'm not willing to give that all to charity yet. And so let's look at some other charitable options which can provide income for the heirs, stretch out the tax liability for them, and still benefit charity in the end. And you guessed it, there are some testamentary life income devices, which I learned about in 1984, called charitable gift annuities and charitable remainder trust. Many of you are exposed to them and worked with them. These are becoming more and more talked about in professional circles, especially the charitable remainder trust, as a mechanism to replace the lost stretch IRA rules for the heirs. So before we get into how we would use it from a testamentary perspective, why would anyone even consider life income gifts as a substitute? Well, it eliminates the 10-year problem because of the 10-year withdrawal rules. They don't have to worry about that. And they may want their heirs to receive income over their lifetime rather than a lump sum with all the temptations to buy cars and boats and vacations. And a charitable gift annuity or charitable remainder trust does that. It basically provides them with what I call a charitable pension plan. So here are the donor profiles who might consider this option. There are more and more IRA owners with large retirement plan accounts, and they didn't always start with an IRA. They retired from their work and they had to roll over their 401k into their IRA. That's where a lot of these sizable accounts come from. And so they've got a sizable account to deal with. It could be a major part of their estate. There are IRA owners with younger adult non-spousal beneficiaries, children, grandchildren, nieces, and nephews who do not want that money dumped on them so that they have to withdraw it within 10 years. And there's also those whose heirs might be in a high tax bracket themselves. A lot of young adults today are 30, 40, 50. That's young in my view. And the last thing they need is a big dump of taxable income in their pre-retirement years. And it's for also the IRA owner who is still charitable and wants to minimize their non-charitable gifts to the federal government, called the IRS. They want to make those dollars go to the charities of their choice now and later. So let's just do a quick review of lifetime charitable remainder trusts. First of all, I first learned about this in 1984. I've implemented many of them and helped donors and their advisors implement many charitable remainder trusts over my financial planning career. It's a wonderful device. I call it the Swiss Army knife of estate planning. And basically, you might remember, here's how it works. You have donors and you have a trust. And in this case, the way I illustrate it is the charitable remainder trust has two things attached to it. One is an umbrella. Now that's a special umbrella. It's a tax sheltered umbrella. And whatever occurs under that umbrella is in a tax-exempt environment. And this trust happens to have a spigot on it that can be controlled in different ways. Okay, so cash appreciated assets are placed by the donor into a charitable remainder trust, which has its own fidelity number. It's not on the books or the balance sheet of the charity. It is its own entity. And then we produce lifetime income to the donor, either fixed or variable, depending on which design they choose. Then at the donor's passing, 100% of whatever is left in that trust transfers to the charity at death, because the charity never held it to begin with. It was in this special trust. Benefits to a donor of a lifetime CRT, they receive a lifetime income. It's like their charitable pension plan for themselves. And frosting on the cake, they do receive a partial charitable income tax deduction based on what they put in, their age, and the Section 7520 rate, we call the AFR rate, which is at historic lows right now. And then at the donor's death, whatever's left in that trust gets paid to the charity outside of the donor's taxable estate. It can't be contested in a will estate by heirs like a will plan can. We know it's going to go to charity, whatever is left at the death of the donor. This is why people do charitable remainder trust during their lifetime. So if you're going to set up a trust, you know, there's a lot of flexibility with a CRT, and you can have more than two life income beneficiaries. You can have multiple life income beneficiaries, and you can have one or more charitable remainder beneficiaries. This is not as easy with a charitable gift annuity, but we'll get into that in a little bit. And you're going to provide them with a sample gift illustration produced by one of your software programs. And then you're going to recommend the donor work with a qualified estate plan attorney to set up the trust. The charity can't set it up. The donor can't set it up. It's a legal instrument. The attorney has to set up the trust to begin with. Let's talk about setting up a charitable gift annuity then during life. Well, looks a lot the same. We have a donor, and we then have a charitable gift annuity. This is not a separate trust. When a donor contributes funds to a charitable gift annuity, they're contributing that money directly to the 501c3 nonprofit institution. But that animal also has a tax sheltered umbrella over the top, and it has a spigot on it that's going to produce income to the lives of the donor. So very similar in that way to a charitable remainder trust. It's another way of setting up a charitable pension plan. It's just a little simpler. Then at death, 100% of whatever's in the gift annuity stays at the charity because it's already on their balance sheet. Didn't have to go anywhere. Benefits to the donor in this case, a charitable gift annuity, the donor receives a fixed lifetime income. And I've emphasized the word fixed. For some donors, they really like that. Others say, no, I want it to go with the economy and variable. Then they shouldn't do a gift annuity. They should do a charitable remainder trust. But just like a charitable remainder trust, during life, you can get a charitable income tax deduction for the part of the assets that you put into the gift annuity based on value of the gift, their age, and the Section 7520 rate. And at the donor's death, whatever is left in the account, it remains at the charity outside of the donor's estate. And we're going to guesstimate it should be about 50% of the original gift left to charity if you subscribe to the American Council on Gift Annuity rates, because that's how those rates are determined and established. So with any instrument, as a certified financial planner, I'd always have to explain to my planning clients their advantages and disadvantages to any financial instrument. With a charitable gift annuity, there's several advantages. You get an initial income tax deduction when you set these up during life. You get guaranteed fixed payments for life that can't vary. You don't have to worry about the markets. Partially tax-free income comes back to you for a specified period of years under the annuity taxation rules. And you can leave a lasting impact in your community through this wonderful plan gift that you can enjoy part of during your lifetime. Disadvantage, basically one, it is not flexible. It's very, very rigid. It's fixed. But the only thing you can change on your gift annuity is to let forego the future payments and give the remainder to the nonprofit early. That's about it. There's nothing else that's really changeable. And some people don't like that lack of flexibility. For them, a charitable remainder trust might make more sense. Okay, now let's get to the topic of the day. How do we use either of these two devices in a testamentary way? Testamentary means you died. Your last will and testament is where that name comes from. So a testamentary charitable remainder trust, you can set one of these up and name it as the beneficiary of your IRA. And then you can name one or more beneficiaries in the charitable trust to receive either fixed payments through an annuity trust or variable payments, more commonly with the unit trust, lifetime payments, or they can actually set it up for a term of up to 20 years. So quite a bit of flexibility there. At the end of the trust period, whenever that occurs, whatever is left in that trust then goes to support one or more charitable organizations, or can even be left to a donor advised fund. So let's just compare the new rules on the 10-year term that you have to pay this out versus the charitable remainder trust. With the 10-year term, if you leave this to your heirs, they're going to be in a higher tax bracket whenever you receive that money at your death. There's no protection of the principal. Somebody can try and swindle them out of it. Their brother-in-law can provide the next best investment that goes nowhere. And they can become that creative spender with their eyes on automobiles, boats, and vacations. Or we can put your IRA toward a 5% unit trust as an example for 20 years or for the life of the beneficiary. They're going to receive regular income payments after your death, whenever your death occurs. You're going to have tax-free growth of the corpus of that trust during the time it's held. It's going to be lower in their income taxes because they're going to only receive taxable income as it comes out to them, like the old stretch IRA would have, and it protects them against predators and creditors. So it is a viable alternative for the donor that really wants to help protect that next generation from others. Now, to create a testamentary CRT, you have to first designate the CRT as the beneficiary of your IRA at death. You do that with the IRA custodian, the bank, the brokerage firm, the insurance company that holds your IRA assets. Then upon the death of the donor, that CRT is then funded at that time with the IRA assets coming out of the custodian and going into that trust that's been laying dormant, waiting for your death to occur. Then the testamentary CRT pays out that percentage that you're selected of those trust assets to a named lifetime beneficiary. When you set up that testamentary term remainder trust, you have to set a rate 5% or more. That's going to be paid out to the heirs after your passing. And then the beneficiaries will pay tax on income they receive each year over their lifetime, just like they would have under the old stretch IRA rules. And I would tell you, it's my opinion, it's going to be taxed much the same way because it's all ordinary income in the 4-tier structure of taxation on the CRT payments. It's all going to be in that ordinary income tier because that was the nature of the asset that funded that term remainder trust. Then upon the death of those term remainder trust beneficiaries, the remaining assets left in the trust goes to the charity chosen by the original IRA account owner. The beneficiaries of the trust cannot change the charity. It's your donor, the original IRA owner, that's going to designate that those funds come back to your organization to continue your mission after the heirs are gone. So here's some considerations. First of all, to set this up, the account owner has to have a CRT agreement drafted by an attorney so that we can name it as the beneficiary of the IRA custodian. And of course, the attorneys don't work for free, so there's going to be a fee for that based on whatever they charge. And the problem with that is, from a donor's perspective, they say, well, I'm not going to use this for 10 or 20, 30 years. I'm going to live a long time. I have to pay for that now just to have it on deck in case I die. Yep, that's right, Mr. and Mrs. Donor. That's how this works. And then, of course, once the trust goes into effect, then there's additional fees for administration and investment advice and that type of thing, tax accounting, which is true with any term remainder trust. So for these reasons, a testamentary CRT may only be appropriate for IRAs with significant value. In my opinion, maybe $500,000 or more would be a good place to start thinking about a testamentary CRT. You get below that and the economics maybe don't work as well. Now let's take a look at a testamentary CGA alternative. How would that work? Well, with your IRA account, you simply name the nonprofit as the beneficiary of your retirement plan because it's the nonprofit that then has to issue the gift annuity. There's no separate trust. And then we have to detail the terms of the gift annuity with the nonprofit and ask them to use the ACGA rates in effect at your death, because we don't know when you're going to die, so we don't know how old the annuitants are going to be at that time. We don't know what the 75/20 rate is going to be, etc. And then you can name 1 or 2 annuitants to receive fixed life income payments from each gift annuity. But you can have multiple gift annuities. In one illustration I did recently, the donor had 3 grandchildren and wanted each of those to have different percentages of their IRA. And so we set up 3 different CGAs, 1 for each of the annuitants, and then split that coming out of the IRA at death. And then at the end of each annuitant's lifetime, whatever is left in the CGA at that point, it's yours. It supports your organization, just like a lifetime charitable gift annuity would do. So when you're creating this kind of an animal, it's kind of like a lifetime charitable gift annuity in many ways, but not exactly. We have to have, the donors have to give special language to the IRA custodian to insert in the beneficiary designation so it's clear what they're doing. And there's some sample beneficiary language that can be provided to you upon request as to what you would give to the custodian of your IRA. It does need a reference that there's going to be a charitable gift annuity set up and so on. It's not simply naming your organization as the beneficiary, or you're going to get it outright and it may not fund the CGA. This language should include reference to ACGA rates in our opinion, which ours does. And if you don't have a CGA program for your organization now, consider working with a third party such as your local community foundation, or we'll help you at the National Gift Annuity Foundation. We've got a lot of experience in that, and that's what we're here for. Let's compare and contrast the Testamentary CGA versus the Testamentary CRT. How would you compare the two? Well, they're both life income gifts for the beneficiaries, and you can set them both up inter vivos during lifetime or testamentary at your death. Research shows that individuals in the mature and baby boomer generation, I am one, are concerned about retirement income. And I can tell you from a financial planner's perspective, as people grow older, they're less and less concerned about interest rates and account values. They're more concerned about getting that check every month or every quarter in their mailbox. They live off of their income. IRA owners with heirs that are non-spousal beneficiaries may not want them to withdraw the entire balance anytime, especially by the end of the 10-year period that's now imposed upon them by the new Secure Act to avoid the penalty. And so if your donor is of that mindset, this is a perfect solution for them. And it could be that their heirs are just in higher tax brackets and they're saying, you know, can you help me, grandma and grandpa or mom and dad? I really don't want a lump of money that's all fully taxable as ordinary income within 10 years after your death. I'd just as soon stretch that out and add it to my retirement benefits. So that's kind of who you might be looking for in your donor base that could benefit from either of these approaches. Let's talk about the charitable gift annuity on a testamentary basis and why it might appeal to certain IRA owners. Well, it's considerably less expensive to set up, like zero, no cost. They like that. And it's less time consuming to set up and administer. They don't have to worry about hiring an administrator. They don't have to worry about the trustee and so on. It's all done for them. And the administrative costs are much lower because we're pooling CGAs together and spreading those costs over large numbers. Some additional advantages are that the testamentary CRT, while it can pay out, it pays out a fixed percentage each year, but on a moving value that changes from year to year. So with a CRT, the advantage is the income can go up and down. The disadvantage is the income can go up and down. And so with a CGA, we know that there's going to be a fixed dollar amount for the life of the annuitant. No market risk. They don't have to worry about what the stock market did or didn't do yesterday, the next big meltdown, the next big depression, recession, whatever all the politicians are talking about. And that dollar amount is determined by referring to the annuitant's age in the contract and the rates established at that time by the ACGA, because we don't know when it's going to occur, but we can refer to it in the agreement in that way. And kind of an unusual little advantage here that I hadn't thought about, the testamentary CGA doesn't have a minimum payout requirement. A CRT for a 40-year-old won't qualify, but a 40-year-old with a CGA will qualify. And so that's kind of an additional advantage, especially if there are younger heirs that you're wanting to benefit. Well, how does this work from a tax perspective? Well, I can tell you there's no IRS regulations on it. There's been no court cases on it. The only thing we have to hang our hat on at this time is a private letter ruling that came out in 2002, I believe it was. It's 2002-30018. And that ruling, the IRS responded to a request for a ruling concerning the tax treatment of funding a testamentary charitable gift annuity with assets from an individual retirement account. Now, that particular taxpayer was not concerned about heirs receiving income. They were concerned about getting a deduction out of their estate as a charitable deduction from their estate, because the estate tax rules were much different back then. The exemptions were much lower. So that was the nature of this rule back in 2002. And so you have to remember that the IRS has weighed in on this only in a private letter ruling, which is not a binding legal precedent. It kind of just illustrates what the IRS is thinking. That's the best you can do with a private letter ruling. So you just need to be aware of that. It's kind of new territory. However, keep in mind the outright donation of IRA assets directly to a charity, which is what happens when you leave IRA assets to a CGA, to a charity. It's not into a trust. It's a well-established testamentary gift, so I have a lot of comfort in that. So how do you implement testamentary charitable gift annuity? And the reason that I wanted to do this webinar is I believe that you as nonprofits are going to be asked by your donors and their advisors, can you help us set up a testamentary charitable remainder trust or testamentary CGA? Because of the change under the Secure Act, we want to kind of replicate the old stretch IRA rules. So I wanted you to be aware that this concept does exist and get set up to be able to respond to those requests, because there's a lot of chatter about it in the professional ranks on national platforms. So here's how you implement a testamentary CGA. They're going to have to jointly determine with the charity the terms in the annuity agreement, and you've signed the annuity agreement while you're living. And those terms include, obviously, who's going to be the annuitant. You name the children, grandchildren, whoever you want to receive the funds after your passing as an income. Their legal name, their date of birth, their address, their social security number, just like if you're setting up a gift annuity for yourself. The age at which the rate of the annuity will be based, okay? And that'll be the age that the annuitant is at your death, and then the frequency of annuity payments, quarterly, semi-annual, annual, and so on. And what charity is to receive the assets following the annuitant's death. If you're hosting your own gift annuities, it's going to be your charity unless you're splitting with another charity. If it's National Gift Annuity Foundation or your community foundation, you can name one or more charities to receive the proceeds at the annuitant's death. These are obvious things that are going to be in any charitable gift annuity anyway. So here's an example, a little case study. We have Sarah Smith here. She's retired now. She's 75. And, oh, hit the wrong button. There we go. She has an IRA worth $100,000. And she's a widow. She wants a 35-year-old granddaughter, Rachel, to receive income upon her passing. She doesn't like this idea of dumping $100,000 on Rachel if Mrs. Smith dies too soon. And she wants to leave a legacy to her favorite nonprofit. She's been wanting to do a planned gift, didn't know she really could afford it. She'd like to give more now, but she needs this income. So maybe a testamentary CGA will really work for her and for her granddaughter, Rachel. Let's see how that would work. Okay, so Sarah Smith has this $100,000 IRA. She finds a charity willing to issue a testamentary CGA and having the right documents and paperwork to do it. And then she agrees to designate that charity as the beneficiary on the IRA account with the custodian. Okay, and so she has this testamentary CGA contract. It stipulates in it that that'll go into effect contingent upon the IRA beneficiary designation remaining in place with the custodian, because Sarah could change the beneficiary in her IRA and not fund the CGA, and on the transfer of the IRA account to the charity. That's when it'll go into effect. We have to be very explicit as to when the CGA actually would go into effect at her death. Okay, so then Sarah passes away at age 95, 20 years later. The account passes from the IRA custodian, from Fidelity, from Schwab, from Vanguard, to the charity. The charity then immediately issues the annuity to Rachel Olson, who is now 55, at whatever the prevailing rates are at that time established by the American Council on Gift Annuities. And then Rachel receives an income stream now for the rest of her life. Now she has a charitable pension plan that no one can take away from her. No one's going to swindle her out of it. Creditors and predators can't get a hold of it. And she's protecting herself from having stars in her eyes and buying the new car, the boat, and the vacation. Then when she finally passes away, whenever that is, whatever is left in that account passes to the charity, or is held by the charity that issued the gift annuity. So it's very similar to a lifetime gift annuity. There's just a delay here as to when the proceeds are going to come back to the nonprofit. And my opinion is, well, you might have to wait for it. At least you're going to get it. If they simply leave the IRA to their children or grandchildren directly, you're not going to receive a dime of it at your nonprofit. Now, many charities will not issue a CGA to a person under 55, some are even 60 or 65. In that case, you might want to build a deferral option into the T-CGA agreement, just like you can with a traditional lifetime CGA. Unlike CRTs, there is no deferral option, which kind of could cut out a testamentary CRT if the heirs are too young, as I mentioned earlier. If the charity and the account holder decide to deferral is appropriate, you just include that in the agreement. And in this example, if Mrs. Smith died when Rachel was only 45 years old, then the IRA account would have passed to the charity with a 10-year deferred CGA created. and then the CGA be fully funded, would continue to grow and beginning making payments to Rachel when she then turned 55, which was that charity's minimum issue age. So that's all doable. So here's how it works at our National Gift Annuity Foundation, which I'm a part of. The donor has assets that go to NGF. When do they go to NGF? At their death, and name NGF as the beneficiary of the IRA. And then NGF makes the payments to the heirs, one or more heirs for their lifetime, and at their passing, then what's ever left it in that account goes to the charity that the original donor recommended. We can actually split it between 2 or 3 charities. If you want to use one CGA with multiple charities, we can actually do that as well. So we just stand in the place of another nonprofit, but we're doing all the administration, we do all the regulatory work, and we do all the investment work, all the tax reporting for you. So again, who is National Gift Annuity Foundation? It's really just a subsidiary of the Decamai Foundation that Brian Klons established in 2003. It's and which was set up as a National Donor Advice Fund for non-cash contributions to real estate, CNS Corp, limited partnerships, and so on. And I would mention that, of course, we're able to fund lifetime gift annuities with all those unusual assets, but that's not the purpose of our talk today. We're only talking about IRAs, which come in as cash. But we can take illiquid assets if you want to set up a lifetime gift annuity rather than turn it down. Even if your organization is issuing gift annuities, we'll take one-offs and we'll do one for you. We'll do one or we'll do 1,000. You don't have to have any contract or anything of that nature. Total unrestricted assets backing up the annuity payments as of the beginning of the year were over $400 million in Decamai National Gift Annuity and their consolidated entities. Very, very strong balance sheet supporting the payments to the donors and their heirs. So in conclusion, just kind of a summary here, the Testamentary CGA is a simple solution. After the Secure X stopped the stretch IRA option, we can protect their account from creditors and taxation in the hands of the heirs. If a donor would like to secure some income for the family member rather than have it dumped on them, they can consider the Testamentary CGA. It's just a simple beneficiary change at your custodian. There's no legal drafting is required. The charity and the donor must also execute this annuity agreement with the contingency that the IRA beneficiary designation still remains in place at the death of the donor. And it's just a simple and elegant solution for IRA account holders and charities alike that came out of a piece of legislation that was passed last December. Pretty cool, huh? It's just another topic that you can open with your donors to get this discussions going. So the next steps, if you're interested in learning how this would work, you can call our office for a virtual appointment. We do Zoom meetings all day long to get your organization set up to offer testamentary CGAs to the National Gift Annuity Foundation or Lifetime if you have the need for that. So there's my contact information. I'm in the Des Moines office, Heartland. Home office for NGAF is in Jacksonville, Florida. And with that, I'm going to turn it back over to Brian to see what kind of questions came in, to see if we can come up with some answers in the time remaining. Brian?
Can you hear me okay, John?
I can.
Good, good. So a couple things. So one, I shouldn't tell you this, especially since it's recorded, but about 5 minutes before we started this session, I said maybe we ought to come up with some sort of stealth questions just in case none are asked, so I can let John know that would have been the worst use of our time ever, because I think we got 32 questions in the Q&A, and I'd asked people to do Q&A, which is fine. I think we've got at least another 30 plus in the chat. So all that is great, great content, and what I really like too are a lot of the questions, in particular around the deferred testamentary CGA. John was sort of answering as the questions were coming in, so how John got through 50 slides in that period of time, I have no idea. But two questions I think are very interesting, and some of which I even have to noodle through a little bit. So some of this is quite new, and as John said, we don't have a lot of tax authority or other type of more practical things, so we're sort of working through this a bit. But the first is, John, what happens if the IRA, let's say, is below, let's say it's $600,000 now, but it is below $500,000 to the extent that's a T-CRT minimum? Or one step further, let's say for at least National Gift Annuity Foundation, the minimum is $20,000. Your charity might be $10,000 or $15,000. What happens if you set everything up and the minimum amount left is not enough to fund that particular life income gift?
On the CRT side, there technically is no minimum. There's the practical minimum for a cost perspective is $500,000. But in fact, I've still got some CRTs out there that have like $30,000 left. I've had them for 25 years. They had 8-9% payout rates on them, and it's still in effect, and that would still work. It just gets kind of expensive. And in that case, you can actually terminate the CRT and let the money go to the charity early, okay? Which I think you might have the same solution for the CGA. We hadn't thought about that. Very good question, Brian. Do you have any thoughts as to how we'd handle it on the CGA side if it came in less than 20?
No, I don't, but we'll figure it out.
We'll figure it out, yes.
Did not contemplate that, but it's something to think about. And I got like 4 or 5 of these that we're going to have some interesting additions to some of our package here. Another great question is, let's say that you've named a specific charity, have the T-CGA language with the IRA and the custodian, but then that charity goes out of business. Do you know what would happen in that case? And sort of as a follow-up, a person asked, and what happens if, whether it's for the T-CRT or the T-CGA, that you might otherwise want to change the charitable beneficiary, so obviously they did not go out of business, but you'd like to change that designation?
Okay. First answer, the designated charity went out of business by the time the annuitant died. The money is still held at National Gift Annuity Foundation. We're not going to keep it. I believe our policy is to look for a like-kind charity and pass the money to another charity. And my guess is we'd probably even ask the annuitant if that happened to see if they have one that would be in the same vein. We do have some policies surrounding that, but the money is still held at National Gift Annuity Foundation, and we're not going to keep it. We're going to send it somewhere, okay? Regarding the ability of the original donor to be able to change, our current gift annuity contracts, even during lifetime, give the donor the option to either make it an irrevocable designation or revocable, depending on what box they check on the application. So in this case, if they check revocable and want to revoke that designation while they're still living, the heirs can't change it, but the donor could. That could be part of the contract, and we would allow that if they elected that upfront when we set up the T-CGA.
Yeah, great question. There are a couple great comments too in the chat. So based on the same question, one would say perhaps including additional language that the CGA would not be created, and in fact it would default to an outright gift to the stated charity. Yes. So that'd be a great sort of
if the amount was too low. Yep.
Exactly. And the other one, which is a very good comment too, which we definitely suggest, is to make sure that there's a clear secondary or contingent beneficiary to the extent that there are any changes, obviously, with the primary.
Yes.
Another question which came up, which is a great question, and I don't think we really have an answer to it per se, but that is around, obviously, the IRA custodians delivering timely charitable beneficiary proceeds, or let's just say bumpy, and in many cases beyond bumpy. Clearly, Johnny Hayes and John Tidd and others are working very tirelessly on that effort to try to lubricate that whole process. But this would really be the same, less a question for you, John, but this would obviously be the same because you've got an IRA custodian making a gift to a charity, whether it's an outright gift or for a CGA, at least in current times. That same bumpiness would continue. And obviously, Jeff Comfort's letter and some of the crescendo work that they've done hopefully will help unhinge that a bit, but we'd sort of be in the same spot. And some of that practically, by the way, might mean you're really setting this up as annual payments, or even if it's not a deferral, that you've got time to be able to receive those funds from the IRA custodian so that you'd obviously have the funds available to then be able to make that first payment. So hopefully that will not even be a question in the next year or 2 or 3, but it's an issue now. So just sort of to make that point.
Yeah, my first call would be to the custodian's legal department and ask them for chapter and verse as to why they aren't sending it out. When they don't respond, my next call is to my friend Johnny Hayes, who has this thing. She's really getting that wired. And guess what? Johnny lives in Des Moines with me. Yeah, not with me. We both live in Des Moines. Let's put it that way. I've known her for years. She's doing a wonderful thing for the charitable industry with her work on that, along with others. You bet.
She is, exactly right. And it goes back to, frankly, the charitable gift annuity and the CGP
Yes.
effort and sort of the lobbying that I was on the board a while back when it was in CPG and over to PPP. But the point here is sort of a quick plug to them is these are the types of things that dues go to that nobody sees. The lobbying, the advocacy, which are critically important for the field. And just know that there's so much where Craig Ruck, I think, is on the call, who's done decades of that type of advocacy, government relations, et cetera. So just a plug for the national organizations, obviously including ACGA as well in that too.
Yes.
Another question, and I'd have to sort of noodle through this a little bit too, but it has come up, is what would the state of issue be? So you're in Des Moines, and you pass away, and you have an IRA. And that then is naming a specific charity, we'll say National Gift Annuity Foundation or a university. And then my child, let's say my son, lives in Arizona. Where would the actual gift annuity contract be in terms of state regulation in that case? And we could throw New York into the mix, but I don't want to do that for any reason. But
our favorite, yeah.
Yeah.
It'd be my opinion, non-legal. We'll have to run this by our legal staff. The gift annuity contract is actually, it's in effect, it's just not funded. If it's in effect at the time that the donor signs that contract during their lifetime, okay? So in my opinion, it would be that IRA owners domicile, regardless of where their grandchildren live, because they can live all over creation, okay? Now, to the extent that it's deemed that it needs to be where the annuitant's living at a time, makes a great case for using National Gift Annuity Foundation because we're registered in 49 states. And that solves that problem. Many charities really fuss with that, and they come to us for states where they're not registered. So, but I still believe that would be the former. We wouldn't have to use our 49 state registration advantage to in that case because the contract actually goes into effect because it then becomes the beneficiary of the IRA at the time that it's signed when the donor is still living. But we better run that past our legal staff, Brian, just to make sure I'm not out of line there.
Sure, no, that'd be sort of our current thinking, to be sure. And maybe one other question here before we do the wrap up. And thank you so much for all these. I mean, literally there are 40 questions in the Q&A, and I've lost count in the chat side. But one other good question really relates to, and I think this is more of an issue on the CRT side, but the whole 10% and 5% exhaustion probability sort of rule as it relates to low AFR, which we're certainly experiencing now, and as that relates to CGAs. And there's been some chatter sort of back and forth, which are good in the chat, but basically saying that obviously the ACGA recommended rates calibrate to that AFR, even at quite young ages. Obviously, there can be some deferral based on that, but that the CRT would be sort of a different, difficult issue, obviously, for very young donors.
Yes.
All things being equal, and certainly the payout requirement being that minimum 5%, which you mentioned. So just making that point is that's yet another consideration for the CGA, as you talked about, versus the testamentary CRT.
Let me pick up. Can I pick up on that, Brian? Because
absolutely.
I should mention that if you want to have our white paper on testamentary CGAs written by our legal staff, 4 pages long, if you email that to me at johnne@nationalgiftannuity.org, I will send you a 4-page white paper written by Ryan Raffin, one of our sharp legal beagles. And in the white paper, he discusses the fact that to the extent that at the time of the death of the donor, that the recipient, the annuitant, is too young to even make the ACGA rates work, we can adjust the payout rate to make it fit. You can't do that with a CRT.
Right, exactly. What I may do is give John's home number here on the call for the recording, and that way you can deluge him in that way. But
oh yeah, that's what I need.
That's right. I know. I'd have to send him an email. I'd be glad to get back.
Yeah.
Well, we are, and John, again, I don't know how you got through that amount of material. We got a great team. John's really been leading this. Again, Mike Carey works with National Gift Annuity Foundation. We got 3 other attorneys on staff really thinking through this, a lot of outside help and counsel and comments as we sort of built out this package. But most importantly, again, it gets back to our firm mission of helping gifts happen that otherwise wouldn't. And as John said, I think very, very well, you've got people who are charitably inclined that had perhaps the stretch IRA as their original solution pre-Secure Act. And hopefully this can be a way, both with CRTs too. So CRTs for certain ones obviously would work quite well. There's a great chat comment, Sheila, included that, keep in mind these are fixed payments for a 45-year-old, and that payment when you're 45 is a little bit different as a fixed payment from a purchasing power perspective when they're 85. So again, there's no magic bullet here, a perfect solution. But for those clients that don't necessarily have maybe the $500,000 plus to put into a CRT, or have multiple charities or multiple beneficiaries that they want to sort of partition that out, that we hope that the T-CGA is at least one additional sort of arrow in your quiver to think about how to provide solutions for gifts for donors in those types of more sophisticated planning, but perhaps maybe for not overly sophisticated donors, because it can be very simple, easy to set up, very low cost, yet just another idea. So with that, I will close. Again, we're not going to provide the slides, as I mentioned, that we had some interesting things that happened a couple years ago when we did that. We'll not go into that for the purposes of this call, but we are providing, again, the full recording. We're going to do another session on Thursday, so if you just didn't get enough today, which I hope you did, we'll be doing it again on Thursday. But if you have any staff members or colleagues you think would benefit, again, we'll be sending out the recording link, and then we'll be sending, obviously doing the additional webinar on Thursday too. So thank all of you, nearly 400 who attended. We do hope that this is helpful, and wish you the best of luck for the rest of the week and the rest of the year. Thanks again.